be seated, please.
The ceremonial sitting to celebrate the centenary of the Supreme Court of the Northern Territory.
Your Honour, the Administrator, Mr Tom Pauling, Madam Attorney, judges, former judges, President of the Australian Bar Association, distinguished guests, members of the legal profession, ladies and gentlemen. I welcome you to this special sitting of the Supreme Court of the Northern Territory to celebrate the 100th anniversary of the founding of the Court. I especially welcome those sitting with me on the bench on this special occasion. Apart from the judges of the Court in Darwin, we are joined by the Honourable Justice Susan Kiefel of the High Court of Australia, representing the High Court of Australia, the Honourable John Doyle, Chief Justice of the Supreme Court of South Australia, the Honourable Terry Higgins, Chief Justice of the Supreme Court of the Australian Capital Territory, the Honourable Justice David Ashley, representing the Chief Justice of Victoria, the Honourable Jeff Eames, Chief Justice of Nauru, distinguished former judges of this court. Today the order of addresses will be as follows. I will ask Bill Risk to provide a welcome to country. The Administrator will address the Court. He is, as we all know, a distinguished former Solicitor-General of the Northern Territory and a man who has made a substantial contribution to the legal profession both in this jurisdiction and beyond its borders. His Honour will be followed by the Attorney. In a departure from the norm, the President of the Northern Territory Bar Association and the President of the Law Society of the Northern Territory have asked Mr George Cridland, a practitioner of very long standing in this court, to address the court on behalf of the legal profession. I will then make the final address, after which we ask that you join us with refreshments in the foyer of this court building. Mr Risk.
Justice Trevor Riley, judges, Administrator, distinguished guests, ladies and gentlemen, I'd like to thank you for giving us the honour of being here today to welcome each of you here on behalf of the Latakia people. It's good that you have come and welcome.
Thank you, Mr Risk. His Honour, the Administrator.
Please, the Court. Chief Justice, I acknowledge the protocol which you have announced. Distinguished guests, ladies and gentlemen, I feel greatly honoured to be invited as Administrator of the Northern Territory to speak on the centenary of the Court. The cordiality of relationships between the Administrator as head of the Executive and the Judge, as it then was, constituting the Court, has over time varied in both content and intensity. 100 years ago, that relationship could not have been more cordial, as the acting Administrator and Mr Justice Mitchell were one and the same person. It was he whom we see on the ladder in the well-known photograph of the proclamation of Palmerston as Darwin and the announcement of the transfer of the Northern Territory from South Australia to the Commonwealth. The photo is on the front page of Valerie Fletcher's book, Commonwealth Takeover of the Northern Territory 100 years ago. Valerie is Justice Kelly's mother. It's also in Justice Milron's admirable book. Justice Mitchell was well liked and respected, having been elected one of the two members of the Northern Territory for the Northern Territory in the South Australian House of Assembly. Justice Mitchell might have expected to be the first Administrator, but it was not to be. He was replaced by Dr John Gilruth as Administrator and by Mr Justice Bevan as the Court. Ernestine Hill, in her 1970 work, The Territory, described it thus: Mr Justice Mitchell thankfully handed over the pandana strings of government. The shabby old residency, as the new Administrator crossed its threshold, blushed under its bougainvilleas in new dignity of a government house. Official and parliamentary parties arrived by steamer, and at the courthouse, Mr Justice Bevan presented to Dr Gilruth His Majesty's Commission. This prosaic description is not historically correct, as Mitchell had left on the SS Montero and passed the SS Mataran, carrying Dr Gilruth and his family at Thursday Island. Gilruth's private secretary was Henry Ernest Carey, who, along with Gilruth, Justice Bevan, and later Carey's replacement as Government Secretary R.J. Evans, were to form a clique, a coterie, and become a source of great trouble in the administration. This, as you might rightly assume, is covered in commendable detail by Justice Mildren in his just-launched History of the Court on its centenary, which will amply fill out the brief tale I will recount. Dr. Gilruth sacked the very popular Government Secretary Nicholas Holtz and replaced him with H.E. Carey, who, as I noted earlier, had been Gilruth's personal secretary. Judge Bevan had stayed at Government House for some weeks following his arrival in Darwin and had formed a strong friendship with Dr. Gilruth. Bevan advised the administrator on some legal matters and, under protest, drafted some ordinances. He had a hotline to the administrator's office, which raised suspicion as to whether he was the administrator's instrument and not an instrument of justice. It was soon to be the commencement of the First World War. Union power was very strong in the small town, tempers simmered, and rumour was rife. Eventually, soon after the armistice, the Darwin Rebellion, as Frank Alcorta called it, occurred, and following a march on Government House, scuffles broke out when Gilruth refused to give an account of his 5 years of administration. This was the 17th of December 1918. In February 1919, Gilruth was recalled to Melbourne, but the Union push for some measure of democracy considered apace. It is to be remembered that on the 1st of January 1911, Territorians were deprived of the vote and any representation, a matter which much concerned Justice Ewing in the Royal Commission to come. It was to be a sore point for Territorians for a very long time. In October 1919, a letter from Carey to Gilruth found its way into the hands of Union leader and council member Mr Nelson. The letter was written when Carey was leaving government employment to work for the cattle barons Vesties, and very indiscreetly suggested closer links for Gilruth with Vesties, including the sale by Carey, Bevan and Gilruth of jointly owned land on the Daily to Vesties. Tempers flared, a meeting was held, a delegation of Tupane the Mayor, Nelson, Bolton and others told Bevan, Carey and Evans that they were to resign and leave on the next ship, which was the Bambara, sailing at 8 o'clock the next day. The conversation is recorded in a long telegram sent to Melbourne the following day. There was more than a hint of riot if they did not leave. As Judge Bevan is recorded to have said, if violence is inevitable, as Councillor Nelson has stated, I am quite prepared to leave the territory in the interests of peace. Carey and Evans were of the same view, and all three boarded the Bambara that evening and sailed on the tide in the morning. These desertions, as the Southern Press reported them, led to heated exchanges in both Houses of Parliament. Senator Guthrie captured the mood. The whole trouble is that the territory has not had a firm hand in control. I do not blame the officials for their actions, but I do blame them for clearing out. Had I been an official at Darwin, I would have been shot before leaving my post. I blame Judge Bevan and Mr Carey and Mr Evans for permitting themselves to be forced out when they were there to represent the government. And I blame the government for not having strengthened them by doing everything in their power to keep those representatives there. As such a robust resolve is not required of you today. All of this led to a Royal Commission conducted by Justice Ewing of Tasmania, who was alleged by some politicians to have put himself forward in an unseemly manner to gain attention, perhaps for preferment to the High Court. His findings were trenchantly criticised by those affected, and having reviewed the whole matter, the Solicitor-General, Sir Robert Garran, found most of the unfavourable findings were not supported by evidence, and many were blatantly contradicted. Included in the criticism was a finding that when Judge Bevan had worked on the wharf to break a strike, he was paid by the stevedore. In fact, he was not paid by the stevedore for his labour, but what the judge was thinking being there is beyond me. Curiously, Nelson, who was at the centre of things in both the rebellion and the ejection of Bevan, Carey and Evans, put himself forward to be appointed and was appointed as community representative on the Ewing Royal Commission and escaped criticism. He was, however, prosecuted for obstructing a Commonwealth officer in the execution of his duties, but acquitted on appeal, and later represented the Territory in Federal Parliament. His son Jock, who witnessed the events at Government House in 1918, later became himself the 12th Administrator of the Northern Territory, and he also represented the Northern Territory in the House of Representatives. Closeness between the Administrator and the Judge was the seed of great suspicion and discontent in the case of Gilruth and Bevan. The relationship between Administrator C.L.A. Abbott and Justice Wells, however, before, during and after the Second World War, was nothing short of acrimonious. There is in Justice Mildren's book an amazing account of the trial of a Major Darrett, charged after the bombing of Darwin was stealing certain items from the loot store. I was not personally aware of this, nor of the confrontation between Judge Wells and Mr Abbott, which included the judge accusing the administrator of lying in a report to the High Court on appeal. In Wells' own words, refuting an alleged conversation with Abbott, he reported, "Relations between Mr Abbott and myself have been anything but cordial for a very considerable time, so that I should not have discussed any difficulties that confronted me with him as a friend." As Justice Mildren observes, I think this must be the only occasion when a judge of the Supreme Court has been forced to put in writing an allegation that the administrator is a liar and has sworn a deliberately false affidavit. I can think of no parallel in Australian legal history. Your Honours, that unhappy time is well past, although Mr Abbott's term as administrator is still the stuff of rumour and criticism. Nothing since then has been a cause for concern as to the relationship of the administrator and the court, and I'm happy to join in the celebration of the centenary by speaking as administrator, knowing I do so with your goodwill. I'm also happy that in my term so far, I have not caused a riot or rebellion, nor have I been expelled. I've been proud to be a small part of the history of this court. Thank you.
Madam Attorney, do you move?
May it please the Court. It is with great pride that I rise today to join in the celebration of the Court's centenary. It is right that the people of the Territory should take pride in their institutions. They protect and promote the system of values to which we subscribe as a community. And we have been well served in that respect by our Supreme Court. As citizens, we sometimes take for granted the crucial role the Court plays in the maintenance of liberty and democracy. It behoves us on occasions like this to reflect upon that role. Our society in the Territory is governed by an overarching set of rules, limitations and guarantees that may be broadly described as a constitution. Under that constitution, it is the legislature which makes the laws, the executive which implements those laws, and the judiciary which is called upon to interpret and enforce those laws. It is a feature of our system that questions will arise as to whether a law breaches one of the constitutional guarantees or is otherwise beyond legislative power. Questions will also arise as to whether action taken by a public body or official is in accordance with the law. At a different level, society has had to fashion mechanisms to deal with allegations of criminal conduct and to resolve civil disputes between individuals. It is essential that all of these controversies are determined by an umpire that acts without fear, favour or partisan influence. That is the genius of an independent and incorruptible judiciary. As we look back over the last 100-year period, we see not only a dynamic evolution of the Territory, but also of the Court. It has grown in size and stature. It has assumed appellate jurisdiction in both civil and criminal proceedings, and it is now comprised entirely by judges from the local profession. That evolution is detailed in Justice Mildren's excellent history. While I do not intend to traverse the many important cases discussed in that history, the Court has made an enormous contribution to the development of the Territory by its skillful interpretation of the statutes, its maintenance of the rule of law, and its vigilance against executive zealotry. Although I am told that politicians sometimes feel the odd flash of annoyance when a policy initiative is thwarted by a court decision, the critical role of the courts in the maintenance of democracy is universally accepted by our political institutions. The relationship between the political executive and the judiciary is one of mutual respect and cooperation. It is not a relationship in which the two arms of government will always agree on all issues, and nor should it be. I have been particularly fortunate in that respect to have enjoyed cordial and effective working relationships with the former Chief Justice Brian Martin QC, whom I'm delighted to see here today, and subsequently with Your Honour, Chief Justice Riley. It is both possible and necessary for the Executive, the Legislature and the Courts to work in partnership, in order to address social issues that manifest in criminal behaviour. Among other things, this involves equipping our courts with powers to adopt a problem-solving approach to the challenges of disadvantage, to address the causes of crime, to identify rehabilitation paths, and to make innovative use of judicial authority. Alcohol reform is presently at the forefront of our endeavours in that respect, with legislation which is designed to address a range of social issues relating to the misuse of alcohol and other substances without resorting to criminalisation recently passed through the Assembly. It includes measures to prevent the commission of alcohol-related offences and the establishment of a specialist alcohol and drugs tribunal with power to make orders for the benefit of people who misuse alcohol or drugs. The character of this new framework is preventative and therapeutic rather than punitive. The Territory is also in the process of establishing a substance misuse and referral for treatment court known as the Smart Court. The purpose of this measure is to reduce the offending and antisocial behaviour associated with substance abuse and to improve the health and social outcomes for people whose offending is related to substance abuse. The program will enable the Smart Court to offer assessment and access to programs and empower the court to make banning and treatment orders. A review has also been established to examine all facets of youth offending in the Northern Territory, from an early intervention strategies through to drug and alcohol rehabilitation, alternative education programs, and tailored responses for young offenders in the criminal justice system. Of course, one of the greatest challenges we face is the reduction of incarceration rates. The Territory is presently introducing a package of complementary reforms designed to reduce the prison population and curb the rate of recidivism. This will include the introduction of new sentencing options, allowing for community-based supervision and prescribed programs directed to drug and alcohol rehabilitation, the development of life skills, remedial driving and anger management. In adopting these measures, we recognise that traditional mechanisms are not always successful. We demonstrate that the law is adaptable rather than static, and we signal our commitment to work with the courts to adopt innovative measures to address social problems that have been compounded by dispossession and denial. This occasion brings together the executive in the person of the administrator as the sovereign's representative, the political arm represented by myself and others here today, and the judiciary represented by your honours. It signifies the Territory's commitment to the rule of law, its respect for the role of the courts, and its belief in the role of Parliament and the people who elect that Parliament in making of our laws. We offer to the Court the congratulations of the citizenry it serves. We express our very good wishes for the future, and we affirm our unqualified support for the institution. May it please the Court.
Mr. Cridland, do you move?
May it please the Court. A number of sobering thoughts have occurred to me in the lead up to these proceedings. I hasten to add that I intend to do my very best to remedy this outbreak of sobriety at the reception following these proceedings. The first of these thoughts is that it is now 20 years since I last addressed this Court on the occasion of the closing down in 1991 of the previous Supreme Court on the corner of Mitchell and Herbert Streets and the move to these premises. This occurred shortly after the appointment to the bench of Mr. Justice Mildred. That was a rather light-hearted occasion, the more so since it took place immediately after a very convivial lunch. I recognise that this is a somewhat more serious occasion and therefore will make no references, as I did then, to a certain mythical member of the bench, Mr. Justice Dieldren, or to a scheme for productivity-based pay for judges based on the promptness of delivery of judgments. Another thought was that it is a little over 40 years since I last addressed this Court as an advocate. It occurred to me that it could become somewhat tedious for me to be rushing up to the Court every 20 years or so. And that if I get another gig in 20 years' time, I'll be doddering up to the court clutching a congratulatory telegram from the head royal personage of the day, or perhaps even from the President of Australia. Perhaps the most sobering thought of all was that I have now been associated with the court for over one half of the period of its existence, having come to Darwin, then a town of about 10,000 people, in December 1955, about 55 and a half years ago, as associate to Mr. Justice Cridland. My very first Supreme Court case following admission in February 1959 was to defend an Aboriginal on a charge of murder arising out of a knifing incident at a card game at Bagot. Tiger Lyons and Dick Wharton were both still on holiday, so the defence fell to me. Although as a one-man firm I practised extensively before the court for several years and have been a litigant on a few occasions, for most of those 55 years my association with the court has merely been as an admitted practitioner of the court. Over its 100 years, the court has had 5 different locations. From 1911 to 42, it was situated in the stone building on the Esplanade. Over and immediately following the war years, from 1942 to 48, it was based in Alice Springs. From 1948 to 65, it operated from a set of Sydney Williams huts on the Esplanade, temporary premises which endured for 17 years. The courthouse on the corner of Richard and Herbert Streets was officially opened in 1965. It had a rather long gestation period. I recall Mr. Justice Cridland carrying on a lengthy correspondence with the architects about the design in my time with him, which ended in June 1958. As Mr. Justice Mildren recounts in his book, the official opening by the then Commonwealth Attorney-General Billy Snedden was the occasion of an amusing prank. As many of you will recall, the facade of the court carried a sculpture of justice with one arm across his body and the other arm aloft administering justice to a kneeling supplicant. Someone had scaled the facade and placed a large serving napkin on the horizontal arm and a tray with bottles and glasses on the raised arm. As I recollect, Billy Snedden thought it was an amusing but childish prank. And now the court has been situated in these salubrious premises for 20 years, and they should last for a while yet. It's interesting to note that at one period of its existence, 1927 to 31, the court endeavoured to emulate the Holy Trinity by existing as a judicial duality. The Commonwealth Northern Australia Act 1926 divided the territory into 2 territories, the territories of Northern Australia and Central Australia. The Supreme Court then existed as the Supreme Court of the Northern Territory of Northern Australia and the Supreme Court of Central Australia with the same judge. The court only ever sat in Darwin as Alice Springs was considered too small and too remote. In 1931, the Northern Territory was reconstituted as one. I suppose the period of my closest involvement with the court was during my 2.5 years as associate to Judge Cridland. In the latter half of 1958, leading up to my admission as a barrister of the Supreme Court of Queensland, I sought employment with the firm of R.C. Ward for the purpose of finding out how a solicitor's office worked in those days. I might add that my admission fee of £50 was financed by a loan from the judge, which was promptly repaid with interest in the sum of 1 bottle of scotch. The life of the court in those days was pretty relaxed. Criminal sittings were held regularly and the list was not very extensive. Civil cases could be brought on quickly whenever the parties were ready to proceed. Undefended divorces by phone call. There was the occasional application for a prerogative writ, usually in respect of licensing matters, and the occasional substantial matter of interest, for example, the noted Admiralty case concerning the MV Rose Pearl, featuring a youthful Lawrence Street as junior to Jack Smythe, QC. Much has been written about Judge Cridland and his contribution to understanding and dealing with Aboriginal accused and witnesses in criminal proceedings, and I would not presume to add to it here. When I joined him, he was in regular receipt of congratulatory correspondence to the USA following the Chambers Brothers Aboriginal whipping case in December 1955. An American friend who'd done a year at the University of Queensland sent me a clipping of an article in January 1956 by Robert Ruark, a noted columnist in the San Francisco News, headed, "Australian Judge Proves There Can Be Real Justice." In the article, he bemoaned the acquittal, despite evidence heavily against them, of the suspected killers of a Negro boy killed for wolf whistling a white woman. He goes on, and I quote, "And then I think of a white Australian judge dealing in court with the greatest white supremacy against the smallest black minority, who has the courage to put reasonably rich white ranchers in jail on the principle of equality and justice for all. I say that this is probably the only country in the world today where this could happen. And Australia and the world might be truly proud of Mr. Justice Cridland of Darwin, Northern Territory, Australia." End of quote. It was related to me that when Cridland arrived in the Territory as acting judge in 1951, on his first appearance in court, he was attired in all the splendour of the red robes, something never witnessed in the Territory before. I'm told that the redoubtable Tiger Lyons was heard to mutter, not so sotto voce, "Jesus Christ, Father Christmas." Tiger in full flight at the bar table after lunch, as my friend Mr. Justice Gallop might recall, was a sight to behold. Large of frame, florid of countenance, wig askew, the bottom of his shirt agape to reveal a cavernous navel. On one occasion he bullied a witness so badly that the judge literally flounced off the bench, slamming his chambers door behind him. I recall on one occasion Tiger's pleadings revealed a somewhat novel legal doctrine. He acted for a number of insurance companies, including the London, Liverpool and Globe, which was represented in the Territory by a resident inspector. One of his statements of claim included a paragraph stating, "The plaintiff will say that the doctrine of the resident inspector loquitur applies." This was, of course, an error in shorthand transcription by a secretary and indicated a somewhat cursory, if any, checking of the document by Tiger. I might add that Dick Ward subsequently filed a defence, a paragraph of which stated somewhat tongue-in-cheek, "The defendant will say that there is no such doctrine in law as the resident inspector loquitur." Cridland was at pains to maintain the majesty of the law to the extent, again I am told, as it was before my time, that he sat, I think at Anthony Lagoon Station, on some cattle ducking case, the details escape me. Exhibit 1 consisting of a large number of cattle being kept in the yards there, fully attired in wig and red robes. I am also told that for many years after, the local Aboriginals incorporated in their corroboree repertoire one featuring that white fella judge in big red dress with flower bag long ahead. The amenities of the court and the judge's chambers were in those days almost as far from the relatively luxurious, hermetically sealed judicial environment of today as a stockman's camp is to the Hilton Hotel. Air conditioning was unknown. All public servants were equipped with their own pedestal fans located under the fronts of their desks to direct a stream of air onto them via their nether regions. The judge had an overhead fan in his chambers and over the bench, and there was another over the bar table. With the elevation of the bench, there was disconcertingly little clearance between the judge's head and the fan when he stood up on entering and leaving the bench. I venture to think that Austin Ash may have been in serious trouble. On one afternoon, the atmosphere in the court was decidedly soporific. On more than one occasion, I gave the judge a bum steer on being rudely awakened with a request for the number of the next exhibit. It fell to me as associate to swear in or affirm witnesses, and I well recall the pigeon admonition used, I would not call it an affirmation, for Aboriginal witnesses. It was not quite as elaborate as that of Magistrate Nichols as outlined in Mr. Justice Milton's book, but broadly similar and delivered with suitable sternness of countenance and, I suspect, to the bewilderment of the witness. There was one bizarre concession to the judge's comfort, in that 8:30 every morning a tall elderly Aboriginal known as Big Arm Charlie would enter the judge's chambers, flush the toilet and remove any frogs which may otherwise have threatened the judicial dignity. When I commenced practice in January 1959, the legal profession in Darwin consisted of 7 practitioners, 3 private one-man firms and 4 lawyers in the Commonwealth Crown Solicitor's office, one of whom was the Legislative Council draftsman. I shudder to think of the number that a census would now reveal, especially given all the additional legal bodies that have grown up over the years. Perhaps I should add to the list of sobering thoughts the fact that, as far as I can see, the only survivors of practice in the Sydney Williams Court are myself, my former partner Harry Bauer, who succeeded me as associate to Judge Cridland in a succession of acting judges, and who retired about 3 years ago, having returned to the bar after 20 years as a judge of the New South Wales Industrial Commission, and Mr. Justice Gallop, the Crown Prosecutor and Civil Litigator for the Commonwealth. We did battle on several occasions. The firm of G.W. Cridland, Barrister and Solicitor has had a total of 4 subsequent incarnations, going first to Cridland, Bauer and Rorison, then to Cridland and Bauer, then to Cridland's, and now to Cridland's MB. I recall along the way seeking to recruit a promising young lawyer named Trevor Riley. I don't know if he remembers it, but as I recall, I visited him at his home, I think it was Douglas Street, Fanny Bay, only to learn that Ward Keller had got there first. It's very pleasing to note that in spite of that missed opportunity, he seems to have done all right. I don't think there are many, in fact probably any, who would concur with the views of the Lord Chancellor and Iolanthe that the law is the true embodiment of everything that's excellent. It has no kind of fault or flaw, and I, my lords, embody the law. By and large, lawyers get extremely bad press, and this is not always deserved. I recall years ago coming across a little rhyme. He saw a lawyer killing a viper on a dunghill close by his own stable, and the devil smiled, for it put him in mind of Cain and his brother Abel. More recently, there was an interesting article by Sydney Morning Herald columnist Richard Ackland commenting on the retirement of Chief Justice Spiegelman and lamenting the fact that, quote, in many ways he leaves the court as he found it, unquote. He goes on in his opening comments, justice is as inaccessible to the ordinary citizen as ever before. Costs have not been contained. Litigation groans under the weight of larger trolley loads of documents. Closed hearings and suppression orders are not unusual. The court's communication skills are under-resourced and outmoded. The registry gives the distinct impression that it does not like to be disturbed with inquiries or requests for information. For the media to look at a file is usually an impossibility, or certainly involves a torturous process of applications hemmed in by brick walls. I note, however, that recently the newly appointed Chief Justice Bathurst has stated his intention to strive to make justice more accessible, and the Commonwealth Attorney-General Robert McClelland has defended lawyers, pointing to the extensive pro bono work undertaken without publicity. Reform in any area is usually painfully slow, but great advances have been made and hopefully will continue apace. So, me and the court, we've been together now for 55 years. It has been an interesting time, and there's no doubt that we've both changed out of all recognition. It only remains for me, on behalf of the legal profession generally, and myself personally, to congratulate the court on the anniversary of its birth and to wish it well.
Thank you, Mr. Cridland. If that offer remains open. Today I am proud to say we celebrate the 100th anniversary of the founding of the Supreme Court of the Northern Territory of Australia. The first sitting of a Superior Court in the Northern Territory occurred in 1875 at Palmerston, which is the original settlement to the northeast of Darwin. It was a circuit court sitting of the Supreme Court of South Australia in what was then known as the Northern Territory of South Australia. The sitting lasted just 2 days. As we have been reminded during these celebrations, regrettably on the return journey to Adelaide, the vessel that carried the presiding judge, Justice Waring, and his staff foundered, resulting in their deaths. Thereafter, and perhaps unsurprisingly, the South Australian Parliament passed legislation authorising the holding of criminal and civil sittings of the Supreme Court of South Australia in the Northern Territory, presided over by a commissioner. In 1884, the relevant legislation was amended to create the office of the Judge of the Northern Territory and allowed for offences to be tried locally by a qualified legal practitioner. The Northern Territory was surrendered to the Commonwealth by South Australia in a process which took some years. The surrender began with negotiations in 1901. In South Australia in 1907, the Northern Territory Surrender Act was passed. The Commonwealth eventually passed the Northern Territory Acceptance Act in 1910. The handover date was fixed by proclamation to be 1 January 1911, and on that date the Northern Territory was declared to be accepted by the Commonwealth as a territory under the authority of the Commonwealth. The Supreme Court of the Northern Territory was established by the Supreme Court Ordinance 1911, which came into force on 30 May 1911. This is the occasion we celebrate today, 30 May 2011. The first judge of the court was Judge Mitchell. He was appointed for a term of 5 years subject to sooner determination and on 6 months' notice being given should the Northern Territory be taken over by the Commonwealth, a condition of limited tenure which would be not acceptable today. In fact, Judge Mitchell remained in office only until 1912, when he was replaced by Judge Bevan, who came with a more regular tenure, being appointed until age 65 years. The modern era of the court commenced with the granting of self-government by the Commonwealth of Australia in 1978. The Northern Territory Self-Government Act established the Northern Territory as a body politic under the Crown. In 1979, the Commonwealth Parliament repealed the Supreme Court Act 1961, and the Northern Territory Parliament passed the Supreme Court Act 1979, which created the Supreme Court of the Northern Territory of Australia in place of the Supreme Court previously established by the Commonwealth. Sir William Foster was the first Chief Justice of the Supreme Court of the Northern Territory. Initially, he was the senior judge, and then for a short period, the Chief Judge, and finally from 1 October 1979, the Chief Justice. He was a champion of the local profession. He warmly welcomed legal practitioners to the Northern Territory and encouraged them to stay. Those who did stay, including the Administrator, myself, and many others present here today, were then nurtured in their careers. He had an enormous impact upon the development of the court as a respected Territory institution. I think of him on this day and how he would view this occasion with a justified sense of satisfaction. He would look at this assembly in this beautiful courtroom, in this impressive court building, and I am confident he would take particular delight in the fact that the bench is comprised entirely by members of the local profession. The comparatively short history of the court has necessarily been intertwined with a small part of the history of the Indigenous people of the Territory. At the time of the establishment of the Supreme Court, the majority of the population of the Northern Territory comprised Indigenous Australians. In 2011, Indigenous Australians comprise approximately 30% of the total population of the Territory. The attitude of the courts to Indigenous Australians, of necessity, has changed over the last 100 years, with fluctuating levels of understanding of and appreciation for the different cultures. The relationship between the court and the Indigenous people, who constitute such a significant portion of the people it serves, has also varied with the changing social and political circumstances that have prevailed at particular times. In the early days of the court, Aboriginal people were treated harshly and unevenly, to quote Justice Mildren. For example, Aboriginal witnesses were treated in the same way as prisoners. They were often held in custody until they had given their evidence for their own protection and to prevent them getting away. Although Aboriginal accused had legal representation, they mostly did not have access to an interpreter. They took little part in the process and, has been observed by Justice Cridland, may as well have been tried in their absence. If an Aboriginal accused was not present, no one would notice this fact. It is only in relatively recent times that things have improved. A new jurisprudence regarding Aboriginal issues began to emerge in the time of Justice Cridland. In 1976, Justice Foster delivered his judgment in the Queen and Anunga, which led to the so-called Anunga Rules, providing guidance in relation to the cautioning of Aboriginal witnesses, the provision of prisoners' friends to assist with interviews, and the provision of an interpreter when necessary. Those rules have consistently been applied by the courts ever since. They have underpinned a fundamental change in how the police and the courts deal with Aboriginal people. In the early 1970s came the introduction of Aboriginal legal aid agencies, both in Central Australia and in the top end. The agencies, which today are continuing to evolve, are at the very forefront of providing appropriate representation to their Aboriginal clients. There has also been a significant improvement in the provision of interpreting services for Aboriginal people, both in the courts and in the wider community. There is now a dedicated Aboriginal interpreter service providing appropriately trained interpreters for both accused and witnesses in court proceedings. Although there has been much innovation and vast improvement in the way in which the courts deal with Indigenous Australians, there remain issues to be resolved. there is a long way to go. One area of concern is the manner in which courts are required to deal with the issue of customary law and cultural practices. Over the period to 2007, this court developed an approach to the sensitive area of conflict between the law of the Northern Territory and the customary law and cultural practices of some Aboriginal communities. The courts accepted and asserted the primacy of the law of the Northern Territory. Subject to that law, issues of customary law and cultural practice were given appropriate weight in determining the culpability of an offender in all the circumstances of the offence. In 2007, the Northern Territory experienced what has been called the intervention. Legislation passed in support of that process included Section 91 of the Northern Territory National Emergency Response Act, which provided that a court in determining sentence must not take into account any form of customary law or cultural practice as a reason for lessening the seriousness of the criminal behaviour to which the offence relates. The effect of that provision, whether intended or unintended, has been held to be that customary law and cultural practice must not be taken into account in determining the gravity or objective seriousness of an offence. This, of course, means that the court must sentence in a partial factual vacuum. Although the level of moral culpability of an offender may have been substantially reduced because he or she acted in accordance with and under pressure to perform a cultural practice, the court is barred from taking those matters into account. The effect is that the court is not entitled to consider why an offender has offended and pass an appropriate sentence. The court is required to ignore the actual circumstances of the offending. The artificiality involved is obvious. The following observations of Justice Brennan are pertinent, and I quote, "The same sentencing principles are to be applied, of course, in every case, irrespective of the identity of a particular offender or his membership of an ethnic or other group. But in imposing sentences, courts are bound to take into account, in accordance with those principles, all material facts, including those facts which exist only by reason of the offender's membership of an ethnic or other group. So much is essential to the even administration of criminal justice." Aboriginal offenders do not enjoy the same rights as offenders from other sections of the community. It seems to me this is a backward step. As we move into the second century of the Supreme Court, we must continue to strive for an ever-improving understanding of the Indigenous people of this territory. Whilst the same law must apply to all, we as a community must be conscious of our differences and make appropriate allowance for those differences. Throughout the history of the Supreme Court, a large part of the business of the court has been dealing with crime. Looking back over 100 years, it is possible to discern a long-term change in the approach to the criminal law by the court and by the community which it serves. There has always been a concern in this community and in communities throughout Australia as to levels of crime and how we should deal with those who commit crimes. This is not a recent development, and it is a fact of life that will be with us for so long as crimes are committed. There have always been those who do not think beyond the response of locking up those who commit crimes and throwing away the key. Those who adopt this superficial warehousing approach to the problem find encouragement in the manner in which crime and sentencing for crime is reported in the popular media, with its understandable emphasis on the sensational and its again understandable failure to fully explain the reasons for decisions made by individual judicial officers. This leads to perceptions that the courts are soft on crime, and then to the phenomenon we now know as law and order auctions in the lead up to any election. Many politicians, at least publicly, feel the need to be perceived as being tough on crime and promise ever more punitive responses. However, behind the rhetoric, I sense a growing awareness amongst politicians, the media, and the wider community of the need to identify and address the underlying causes of crime. There is, it appears to me, an increasing understanding that if we are to reduce crime and enjoy a safer community, our attention needs to be focused upon addressing the reason for the criminal activity in an endeavour to ensure such activity does not occur or does not occur again. The earlier a problem is identified and addressed, the greater is this prospect that it will not lead to criminal activity. If alcohol is a problem, or if drugs or gambling or anger management or some form of mental illness is a problem, then it is cheaper and more effective to endeavour to deal with the problem before any crime is committed, rather than in the sentencing process after a crime is committed. Once a crime has been committed, there is an even greater need for a focus upon rehabilitation as a part of the response. Commenting on the Productivity Commission's 2010 Government Services Report, which recorded the Northern Territory as having the highest recidivism rates in the country, the responsible minister is reported to have promised a stronger focus on rehabilitation, education and training in a new era in corrections. Whilst public denunciation, punishment and the need to protect the community will continue to be necessary and significant elements in determining an appropriate sentence, issues of prevention and rehabilitation are increasingly recognised as being important factors for consideration in our endeavour to reduce crime. The wider and the more effective the rehabilitation programs delivered, both in custody and in the community, the greater the prospect that recidivism will be reduced. In the Northern Territory, as in many parts of Australia, new sentencing options are being explored. We actively pursue a policy of diversion for juvenile offenders in appropriate cases. Wherever reasonably possible, we seek to keep juveniles out of the criminal justice system. We are now identifying offenders with drug problems and encouraging them to undertake appropriate rehabilitation programs. We reward such offenders with reduced sentences when they succeed. We are experimenting with ways of identifying people with problems with alcohol and endeavouring to direct them into rehabilitation programs. We have an alcohol court to deal with offenders who have an alcohol dependency. We are trying new approaches. In recent times, a fresh and wide-ranging initiative to address the vexed problem of alcohol abuse has commenced. It is, as yet, too early to measure the impact of the initiative. However, the fact that the issue is being discussed and is the subject of both debate and action in our community is to be welcomed. I would like to think that there is a developing political and community will to address the alcohol problem along with other causes of crime. I hope that there is an increasing acceptance that the need to pursue enlightened policies does not have to be accompanied by the need to disguise those policies with other punitive measures designed to fuel the public perception that the legislature is tough on crime. There is much thought being given to alternatives to ever-increasing periods of incarceration as a means of reducing crime and recidivism. There is, I am pleased to say, room for optimism. It was 100 years ago today that the Supreme Court of the Northern Territory commenced. Much in the world has changed dramatically in the intervening 100 years. However, some things have remained constant. Importantly, the guiding principle of this court has been, is now, and will continue to be, to do right to all manner of people according to law, without fear or favour, affection or ill will. That remains our promise. Mr. Grant, do you move? Mr. Wow, do you move? Mr. Karczewski, do you move?
I please the court.
Mr. Tippett, do you move?
I please the court.
Ms. Webb, do you move?
No.
Ms. Cox, do you move?
No, please the court.
Mr. Wyville, do you move?
I please the court.
Mr. Lawrence, do you move?
May it please the court.
Mr. Stewart, do you move?
Please the court.
Are there any motions from the bar? Thank you. Thank you, ladies and gentlemen, for your attendance here today on this very important occasion. That completes the formal ceremony. I invite you to join us in the foyer for refreshments. Adjourn the court, please.
Silence or stand.